Shall be heard. God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
Good morning. Mr. Wilkins.
Good morning, Your Honor. May it please the Court. My name is Douglas Wilkins. I represent the plaintiffs' appellants, Friends, and Fishers. Michael Messi represents the other appellants group, and will argue briefly after I'm concluded. This case presents two primary legal issues. First, did the Commissioner of the Department of Environmental Protection apply the correct legal standard? And second, did she exclude evidence that was relevant on the standard that she did apply? These questions arise in the context of an appeal from a DEP decision approving a groundwater discharge permit. The groundwater in question, the discharge in question, goes into the groundwater where it goes eventually into the Edgartown Great Pond at Mashacket Cove. The Edgartown Great Pond is, as you know, the subject of this Court's decision in Johnson versus the Town of Edgartown, and DEP's findings in this case confirm what the Court said in that case. This is a highly fragile environment. It is vulnerable to nutrient pollution from nitrogen, which causes plant growth and acts as food for the algae, etc. This particular wastewater treatment plant imports nitrogen from outside the pond's watershed, which is an important part of the case. In fact, the testimony was that about 95% of the influent comes from outside the pond's watershed. That's at transcript page 424. Our main point here is that DEP should have asked, does this permit assure that the plant's discharge will not contribute to conditions of water pollution that violate the Department's regulations within the Edgartown Great Pond, and particularly in Mashacket Cove?
Mr. Wilkins, can I ask you a question? You said 94% of the nitrogen comes from outside the watershed?
That's what the testimony is at page 424.
What about that chart that shows that 30% come from septic systems,
I'm referring to the
14% from farms?
I'm referring to the plant's influent, Your Honor.
Oh, the plants, not the total nitrogen coming to the pond.
Correct. Now, the question that we say the Department should have asked is based squarely upon the regulations. The first regulation we rely on is 314 CMR 506, which says the Department shall not issue a groundwater discharge permit when the discharge will cause or contribute to a condition violating the groundwater or surface water standards. Now, we've referred to this in shorthand in our brief as the no contribution rule, and I think that may have led to some confusion in the responsive brief. So let me be clear about what we're saying. We're not saying that the plant can never contribute nitrogen.
No, I understood that, and
Okay.
I took your reply brief, and I don't take that as the argument that the
Okay,
that
what
the
we are
plaintiffs
saying is
making.
that the plant cannot contribute to
No, of
pollution.
course not.
And it's a straightforward question. Will the wastewater treatment plant contribute to the violation of groundwater and surface water standards? Now, the second regulation we rely on is actually a group of regulations. One of them is 314 CMR 607, which says that DEP shall limit or prohibit discharges to ensure that the water quality standards of the receiving waters will be maintained or attained. Now, again, in the responsive brief, there's been some debate as to whether that applies. We submit that the receiving waters and certainly the down gradient waters include the waters of the Edgartown Great Pond. But this concept of assuring compliance with the Department's regulations appears in other regulations, which we've also cited, 314-501, 314-510. So you put the two regulations together, and the Commissioner should have asked the question that I posed earlier. Instead, the Commissioner decided to allocate a certain amount of the supposed plant's assimilative capacity to the pond's assimilative capacity to the plant. And
Why isn't that a reasonable way to approach a very complex environmental problem in which lots of regulations may or may not attach and lots of judgments have to be made about how to, limit and control the nitrogen inflow into the pond? Why isn't this a perfectly reasonable approach?
It's not reasonable because it's not what the regulations require the Commissioner to do, Your Honor. The Commissioner, I suppose, could have had a different set of regulations. It could have had.
You're saying the allocation process violates the regulations. It's not permitted by the regulations.
She didn't ask the question that she's required to ask by the regulations.
Which is, again?
The question she should have asked is, will this discharge cause or contribute to a condition that violates the groundwater or surface water standards?
Well, but the discharge we're talking about is not a greater discharge than the discharge that existed before the new facility was online, right?
Yes, but that's not the standard either.
I know, but doesn't that end up being a ridiculous result? You put a new plant online which discharges less nitrogen, yet it of course will contribute in some respects. The prior plant contributed a lot. This plant will contribute a lot less. But the regulations say you can't do it?
No, Your Honor, it's not ridiculous for the following reason. If I thought there was only one solution to this problem, I would come to the court and ask the court to impose it. But there are a number of solutions to this problem. And again, in the responsive briefs, they've said we've asked to shut the plant down. Well, there are a lot of other things that can be done and that must be done if you ask the right question, that is, if the department asks the right question. For instance, there could be a limitation upon importation of nitrogen from outside the pond's watershed. For instance, there could be a different outfall location that doesn't.
But how much? I'm trying to understand here. The amount of nitrogen that will come from this plant is such a small percentage of nitrogen that actually will get into the pond. Aren't there a lot of other things that can be done?
It's not a small percentage, Your Honor, for a couple of reasons. For one thing, it's projected to be 14 or 15% in the future. But for another thing, we've relied upon the same expert analysis that the department relied upon, namely the so-called Wilcox report, the 604B report, which evaluated a number of scenarios, 9 scenarios, in fact, depending on what it turns out the pond can actually tolerate. That was three parameters, and also how much growth there will be in nitrogen load in the future. Under 3 of those scenarios were essentially rejected because they're too risky. Of the remaining 6 scenarios, in 4 of them, the pond cannot tolerate the nitrogen that goes into the pond. In 2 of those 4 scenarios, Your Honor,
the pond cannot tolerate. Explain that to me again. The pond will not be able to tolerate what nitrogen?
The total nitrogen that goes into the pond.
That's coming from all potential sources.
Correct.
All right. And how much of that will be coming from the plant under those scenarios?
Well, the permit allows
whatever the plant is contributing, correct?
Well, yes, but the plant is allowed to contribute 2,200 kilograms per year. And that, by the way, is the important way to look at it. This is food, so we look at how much food is going and not what the concentration is.
This is what they're allowed to contribute, 2,200 kilograms.
Correct.
And how much is it contributing?
Today, it's less than that.
A lot less than that.
Yeah, but I take it your point is if you give a permit which permits you to increase that up to a far greater level, and you're not looking at the total capacity, then you have a potential problem.
Correct, Your Honor. You can't look at part of, if you're going to look at the pond's total capacity, which is what the department did, you can't look at only the plant. You've got to let me ask my questions, and this is my evidentiary point. You've got to let me ask the questions about what's going to happen with the other pieces of the puzzle. You can't just look at one piece of the puzzle, which is the plant.
Mr. Wilkins, can you... Go ahead, Justice Sosin.
I'm a little confused. Under the various scenarios, is it correct that your calculation is that the nitrogen sources, the other nitrogen sources, by themselves, are already going to put this pond over the limit?
No, Your Honor.
No.
And in fact, this connects with what I was about to say in response to Justice Cordy's question. Under 2 of the 6 scenarios that are not risky, the plant's discharged 2,200 kilograms accounts for the entire excess over the pond's assimilative capacity. Those are the...
Explain that in English.
Okay.
Entire excess over the simulated capacity.
It sounded like English to me.
Well, it doesn't sound like it.
Okay. I'm sorry, Your Honor. Let me translate my own remarks. Under the medium load limit scenario and the high growth scenario, the pond's ability to tolerate nitrogen is exceeded by 1,900 kilograms per year.
But that's if you select the high growth projection.
Yes, these are all plausible scenarios, Your Honor.
Okay, but let me ask you this, your question in a slightly different way. What is, or what water quality standard is being violated by the plant's contribution of effluents?
We've listed a number of them, Your Honor, and there's evidence in the past that this pond has had eutrophication events. That it has an impact on benthic organisms. It has an impact on water clarity. It has an impact upon shellfish. It has an impact upon fishing in the pond. I mean, these are all, there are more as well. There's a whole panoply of water quality regulations that are violated. And there's also what the commissioner relied on was a limit on nutrients sufficient to control eutrophication, which is excessive plant growth. These are all the water quality standards that we say the commissioner should have looked at and said, if I allow this discharge, which is going to reach the pond in 15 or 20 years, will there be a violation of water quality standards? And the only way to answer that question is to do what Mr. Wilcox did, to look at scenarios, because we can't predict the future. And
Mr. Wilkins, I understand about the scenarios, but I'm looking at your reply brief and say, if you're looking at this particular permit, you have to look at the plant's contribution of nitrogen to the pond, and the pond's assimilative capacity and the anticipated annual load to the pond. I mean, the scenarios, I take it, are the anticipated annual load to the pond, correct?
Correct, Your Honor.
I'm really trying to, maybe now I want to talk in English, Justice Cordy, but I mean, you know, the department has to make a determination, not knowing whether there's going to be an enormous amount of growth, not from the plant. I mean, what do we do in those circumstances? We say, you may have high growth, therefore you should limit the capacity of this treatment facility?
What I think she has to do, and this is why you have to look at the scenarios and why the regulation refers to assuring, because there's uncertainty. She's got to look at all these scenarios, and she only looked at one. You can't look at one and say, well, we hope that the other ones won't occur.
But this license is not forever. And
No.
this is not the only effort that's involved in trying to limit the other sources of nitrogen. So you can't look at this in isolation and say, I mean, it just,
I asked to get into those other sources, Your Honor, and I was denied the opportunity.
but that's got nothing to do with this 5-year license.
Yes, it does, because this, in the future, is when this discharge is going to reach the pond. So we have to look at what the future load is going to be. It's not going to reach the pond. It probably hasn't even reached the pond now. We've been at this for 10 years because we started in 1996. So I have to be able to ask that question, and the commissioner has to look at this issue in terms of, is there going to be a violation of water quality? She can only look at that by looking at the scenarios, several of which say this plant is going to be responsible for the pond exceeding its capacity.
But why do you say she didn't look at those issues? They were in the Wilcox report.
Yes, but what she did was she picked one load limits possibility out of the Wilcox report. She looked at a piece, that's on one side of the equation. She looked at a piece of the puzzle on the other side of the equation, namely the plant's inflow, and precluded inquiry into the other pieces of the puzzle. And you can't answer the question of whether this pond's capacity is going to be exceeded unless you look at all pieces of the puzzle on that side of the equation.
Mr. Wilkins, when you say she precluded inquiry, Wilcox was basing his, 6 scenarios on looking at the other pieces?
Yes.
So what is it that you couldn't look at?
I was not allowed to inquire into whether there were measures to, for instance, Wilcox had a panoply of things you can do to reduce nitrogen load, and I was precluded in
things you can do not relating to this permit.
Exactly.
Hook up septic systems.
Exactly.
Well, that seems to me to be part of a larger solution, but are you suggesting that unless the entire solution is fixed, at this point in time, no solution, no partial solution can be permitted?
Well, this is not a partial solution, Your Honor. This is a permit for a discharge.
5-year discharge.
This is a permit for a 5-year discharge, and there are no conditions. For instance, Your Honor referred to hookups. There's no condition that hookups be required, that capacity be reserved for that. There's no comprehensive analysis of why this discharge is going to work in the total context of the insult on this pond.
I have not read the Wilcox report. The scenarios on which what's the underlying data from which he developed his scenarios?
Well, Wilcox developed the data from there's some, should we call it oceanographic or technical. I'm trying to reserve some time for Mr. Nessie here.
That's okay. You're not eating into his time.
Okay.
Don't worry.
Okay.
You can
but
relax.
There's an array of oceanographical and water type analysis relating to what the pond can tolerate. Then
I
there
mean,
was,
was he looking at some of the other factors, what the rate of growth had been in the watershed?
yes. Yes, he was looking at capacity for growth in the watershed, predicted future growth, what the load is likely to be under various scenarios.
Okay. Thank you, Mr. Wilkins.
Thank you, Your Honor.
Mr. Nesi?
Yes, good morning, Your Honors. Michael Nessie, I represent the 10 Citizens Group, and I'm just going to make a couple of quick points for you today. Again, I think it's important to stress that Judge Nee, the administrative law judge on this matter, asked and answered the wrong question in his decision. The question that he posed was, will this discharge at 3 parts per million coming from this new wastewater treatment plant help control eutrophication in this pond? That is not the question that is posited by the regulations. The question is, will this discharge cause or contribute to eutrophication in this pond? And we submit that it will. Nitrogen here is the culprit. Nitrogen is a basic element, and it has a dramatic impact on these types of sensitive coastal embayments. The ambient...
Well, may I ask you then, any discharge would contribute, wouldn't it?
Well, Your Honor, please, if the discharge contained no nitrogen or less than 0.07 parts per million, which is a very low standard, but that is the ambient standard. That is the ambient amount of nitrogen generally found in clean and untainted coastal ponds. 0.07 parts per million of nitrogen. And the problem is, and part of the problem is that this is a moving target, and that the science in this area is being developed through UMass Dartmouth right now in the Mass Estuaries Project. And this Edgartown Great Pond is on the list of ponds to be studied, empirically studied, which has not been done yet, and which you will note that the 604B study is not an empirical study. There was not testing done at the time. There was not there were not samples taken of the water to test what the conditions of the pond are now.
Mr. Nesi, I understand your focus on the regulations, and I don't fault you for doing that, and I'm just trying to stand back. Am I correct in understanding that the water treatment facility that was discharging into the watershed, that this will improve the quality of the discharge from the point of view of nitrogen?
Yes, I think that's generally correct, that the new plant is just discharging currently between 2 and 3 parts per million nitrogen in 100,000 of gallons a day, depending on the time of year. In summertime, the tourist industry creates quite a bit more.
And the prior plant was 30 milligrams per liter.
Right, up to 30 million. The prior plant was overwhelmed, simply overwhelmed.
Right, and at about 200,000 gallons a day.
Right, and
But you know what your argument sounds to me, though? This is the problem. This is sort of a common sense problem. Your argument would be consistent with this. Let's take the 600 septic systems in the area and build a treatment plant, and we'll funnel all of that into the treatment plant, and we'll reduce the nitrogen by 20 times. Your argument would still be, well, you're still contributing to the pond, and where does that lead?
Well,
this process?
I think you're making a good point in that this is a very difficult problem, and this is where nature actually is showing us that maybe our best efforts aren't good enough, and to prevent the type of eutrophication event. I should just point out that the Mass Estuaries Project is currently, in their research, they're showing that anything over 0.3 parts per million will tend to cause eutrophication in these sensitive ponds, and that even at the current discharge of 2 to 3 parts per million, that's 10 times greater than the research is
But what's the water quality standard that has been set by the department?
Well, that is defined in the regulations as would the discharge cause or contribute to eutrophication? So there is no numerical standard because, again, the science is being developed.
And
what's the groundwater standard, though?
I'm sorry, Justice Stewart.
There is a groundwater standard.
There is a groundwater standard, and the groundwater standard is that the discharge into the groundwater shall not.
It's 10 milligrams per liter.
Well, that's for drinking water, right? That would be the standard for drinking water. In other words, human consumption would be 10 parts per million or 10 milligrams per liter.
So what is the regulation talks about causing or contributing to a, quote, violation of ground or surface water quality standards.
Right.
What is the standard that you say is being violated?
That standard.
Which one?
That
10 milligrams.
Well, no. That the discharge is, and this is in violation of the groundwater regulations, this discharge is violating or is causing the surface water quality standards to be violated. And the groundwater standards say you shall not cause or contribute to further degradation of water quality standards downstream, which is not a numerical number. There's not a numerical standard, but it does tie together.
Mr. Nessie, one last question for me at any rate. Is there essentially what the Department of the Commission is confronted with is a treatment facility asking for a permit, one permit,
yes.
Correct? And as I hear the argument, what you're asking her to do in deciding whether or not to grant that permit or to issue the permit in a modified form is to look at the totality of the circumstances.
Yes.
What's the best case that says that's what she should be doing?
I would suggest that in this, actually, when we first appealed the 1996 permit, the ALJ we initially had set this down as a standard to be looked at by DEP, and that was given current site conditions.
Right.
Does the discharge cause or contribute to?
Okay, so given current site conditions, what does that do to the scenarios of the Wilcox report that are not current site conditions but are anticipated, growth, whatever it is?
Right. Well, I'm not sure how, even though I know the DEP relied on the 604B study, and,
right.
and we went along with that analysis, I'm not sure how valuable that analysis is in terms of protecting the pond. And the other difficult, quite frankly, the catch-22 here in a sense is that the permits are only for 5 years, and by the time you get through the the administrative appeal process, the permit's over and moot, and then on top of that, it takes 15 years for this discharge to hit the pond. So,
if there's no numerical standard that is being violated, what's wrong with looking at this problem from the perspective of improving what's actually taking place?
Well, on the surface, if you will, perhaps nothing, but it does not, and it will not, allow this pond to recover. And that's the problem, is that the biology is such that anything, as I've tried to point out, anything over 0.3 parts per million will not allow the pond to regain its health.
So your non-contribution argument, or the non-contribution argument, in fact, would result in shutting the plant down.
Well, or you can treat this discharge further. You can reduce the nitrogen in it down to I'm not
still
sure
contributing.
Exactly. Sorry?
It's based on what your argument is. It seems to me that so long as there is any nitrogen in the effluent, it can't continue.
Well, as I say, I believe you can reduce the nitrogen content in the discharge down to extremely low levels if you really wanted to, and perhaps even to zero. I mean, there are technologies out there that would allow that. They cost money, and you can understand that the town's resistant to do that.
Thank you.
Thank you very much.
Ms. Lamb?
May I please the Court? My name is Sue Lam, Assistant Attorney General representing the Department of Environmental Protection. I will take 8 minutes of the appellee's argument time, and Ms. Goodhart will take the balance. as the citizens groups do acknowledge here, is that the treatment plan, the state-of-the-art treatment plan, is actually a part of the solution, not the problem. It actually helps contribute to controlling eutrophication, controlling the water quality problems in the pond. As you recognize,
that's all well and good, but the Friends and the 10 taxpayers are saying, but it's still contributing to a violation.
Their approach, we took the reasonable approach in looking in all.
But why did you write why is the regulation written the way it's written? Is it addressing the no contribution to a violation circumstance?
The regulation does not require a no contribution approach as they are trying to advocate here. The regulation allows the department to adopt this reasonable approach in looking in the totality of the circumstances in this case.
And which regulation in particular are you pointing to?
The same regulation, cause or contribute. And if you're looking at, also if you look at that language in not separate from the surface water quality standards,
which regulation are you looking at?
314 CMR 506 and 519.
Okay.
It's essentially the same language. We're saying that our approach does not violate that language.
And that's because, as I understand it, make sure, the ALJ found that the projections, which obviously have a lot of assumptions in them, but the projections of where we will be in 15 to 20 years in terms of what's coming from other sources, what's coming from the plant, the ALJ was satisfied that the water quality standards are not going in the pond are not going to be violated 15 or 20 years down the road.
That's correct.
Now, I take it some scenarios would indicate that they will be. I mean, if you make certain assumptions about growth and blah, 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 some scenarios do lead to a violation of the standards. How do we, what do we look to say, well, the acceptance or the rejection of certain assumptions is permissible in terms of which scenarios you get to look at?
Okay. There are a couple of answers to this. One is that in making those assumptions and in adopting the scenario that in which this permit will not violate water quality standards, the department looked to an expert report that the citizens groups have relied on, and they have not produced any evidence in challenging that. That report actually recommended those limits. That report actually say this is the most likely growth scenario that is going to happen. And it also adopted a very conservative limit for the pond. In fact, it says, at one point it says that the pond could actually tolerate more nitrogen than this limit. But to be conservative, to err on the side of caution, we adopt this particular limit. And the department adopted that recommendation. And so this scenario is actually a very precautionary scenario that we looked at.
So you're saying it's in essence it's the equivalent of a factual finding in terms of this is the likely projection of where we will be 15 to 20 years from now when this nitrogen reaches the pond, and we find that we're satisfied that, with accepting all these assumptions, we're satisfied that it's going to be below.
That's correct.
So you're saying that you don't really, there's part of me that says you don't really disagree with the legal interpretation that's being put on this regulation, but you are relying on a factual a way of finding the facts, a certain method for finding the facts that will assess the issue.
Well, twofold. We do argue that this is actually a factual finding, a reasonable finding based on substantial evidence in the record. And the second thing is that we do find their interpretation of the regulation of no contribution approach
It's a factual finding on which you're relying based on this treatment facility operating at full capacity?
Under this limit, it caps it at 2,200 kilograms, no matter how, whether or not, what volume they're discharging at. It caps it at 2,200 kilograms per year.
And what happens as I was reading through this, what happens if the plant begins to hit 80% of that maximum capacity.
The town is supposed to notify the department and also develop a plan to ensure that it actually comes under that limit. In addition, it also takes into consideration all the other plausible high-growth scenarios. In addition, the permit requires the town to conduct a nutrient management study that will look at all these sources and will develop a long-term strategy in controlling them. That is part of the way that the department is deferring to the town to look to future conditions to ensure that the pond's water quality standard is not violated.
Well, Mr. Wilkins is saying he didn't have the opportunity to cross-examine Wilcox about his selection of the moderate growth projection. And this whole factual finding depends upon that moderate growth projection. Why wasn't he allowed to?
No.
Why isn't that an abuse of discretion?
The ALJ did not allow him to inquire into what is happening with sewage, with septic system hookups, with regard to lot sizes.
And why not?
Because it's not relevant in this permit.
Why not?
Because it's problematic through this groundwater discharge permit to require the town to hook up septic systems.
It's problematic?
Yes, it is problematic. Septic systems that's operational, it's not in violation in any regulation to require the town to hook that up.
But isn't it also problematic because the fact that they're not being required to hook up means that the effluents from these homes that are out there is also flowing into the pond?
That's correct.
But did Wilcox assume that was not going to improve in any event?
That's correct. That's correct. It's not going to improve.
It's going to get worse.
It is going to get worse.
But isn't that Mr. Wilkins's point? It's going to get worse.
But this plan has a capacity to address that question.
Only if they hook in.
How does it have the capacity to address that question if it gets worse?
Because it has, it's not discharging at full capacity right now.
It's only discharging at about one-third capacity. So theoretically, new growth could be hooked up to the plant.
That's correct.
Correct? And there would be plenty of capacity to manage that new growth.
But you're giving a straight permit. You're not requiring any hookups. You're not requiring to monitor. You're not saying the plant can have this capacity if this is the level of growth. But if the level of growth is this, the plant's capacity must be limited. Correct? You're just saying the plant can do this, and we think it's going to be here, but it could be up there, and that's too bad.
Based on the science, based on the recommendation of this report, that's not likely.
Well, I'm looking at the ALJ's thing, and he says, I rely on the conclusions of William Wilcox. How do you address the plaintiff's claim that the commission essentially selected which of the Wilcox scenarios she wanted to rely on?
That's not correct, because the Wilcox report actually recommended this one scenario in which the department actually adopted.
Well,
as the most likely scenario.
As the most likely scenario.
And I suppose he's going to have to live with it, too, or the town's going to have to live with that selection now, because the plant cannot exceed 2,200, whatever it is.
Kilograms.
That's correct. Okay. And in summary, I mean, as I think the citizens group's approach really doesn't make any practical sense. You would have to stop any kind of discharges that would actually benefit the pond. And the permit is reasonable in protecting the pond's water quality standards and should be affirmed.
Thank you, Stan. Ms. Goodhart.
Good morning, and may it please the Court. I'm Lisa Goodhart for the Edgartown Wastewater Commission. From the town's perspective, it's ironic that this permit for this plant in this location is being challenged in the name of protecting Edgartown Great Pond.
I understand that. In theory, I understand the argument that says I've got a lousy plant, and now what I'm going to try and do is build a better plant, and the town is saying, well, thank you, la-di-da, I'm getting slugged for this. But that's really not the question, I think, correct? The question is, does it comply with the regulations? It may be unfair, it may be crazy, it may be whatever from the town's point of view, but the question is, could this permit issue?
And the court, the DEP made findings that this plant could be issued, factual findings that supported its conclusion that this plant does comply with all of the applicable applicable regulations. And the key finding is that this plant, with the permitted levels of nitrogen under this 1999 permit, will contribute to controlling the eutrophication of Edgartown Great Pond.
What is being violated here? What is the projected violation that is the subject of these hearings? The violation of ground or surface water quality standards?
There is no violation, Your Honor, and that is why the permit should be affirmed. The applicable groundwater quality standard is a 10 milligram per liter standard. This plant is discharging between 2 and 3 milligrams per liter. That is a level that is cleaner than brand-named bottled waters like Evian and Perrier. The applicable groundwater permitting permitting regulation, that's 314 CMR 510-3.
Well, when you say there's no number, is the number 10 milligrams per liter?
The regulations provide 10 as the number in 2 places, and they also provide, to the extent that the surface water regulations are incorporated by reference, they also provide that the DEP shall apply an appropriate site-specific limit. And DEP relied on the Wilcox report to find that the appropriate site-specific limit was 15,513 kilograms of nitrogen per year for the whole watershed, and within that allocated 2,200 kilograms per year to the plant.
So is the violation, is it something that's articulated somewhere? The violation that is being contributed to?
Can I ask the same question in a slightly different way? I'm looking at I think it's on page 850 of the appendix. And here's the state. I reject the petitioner's contention that because the pond suffers from excess nitrogen loading, is that saying that he accepts that there is excess nitrogen loading in the pond? I mean, is that what we're dealing with? You start from the base. That's another sort of. In other words, is there excess nitrogen loading?
I think what the ALJ was saying is that the current conditions of the pond, which of course reflect historical discharges long before this permit, long before this $13 million upgrade was done over a period of 15 years, have resulted in a fragile condition where the pond currently is on the brink of being over-eutrophied. What are we going to do about that?
Well, is it he or she, the ALJ?
The ALJ was a he, Judge.
Okay, the he. Okay, so he says, I'm going to reject that you have to be essentially nitrogen-free, or as close to nitrogen-free. He says for 3 reasons. First, closing the plant, which provides many environmental benefits, or maybe it does, maybe it doesn't, would reduce the nitrogen entering Edgartown Great Pond by only 8%. I don't know what that means, because, let me just finish. Second, closing the plant would foreclose the possibility of eliminating any of the septic systems in the pond's watershed. But there's no requirement that there be any effort to do that. And then third, he says, because if the homeowners cannot hook up, you're going to have it worse. And third, the argument for a complete ban ignores the specific standards contained in the surface and groundwater standards, and I don't see the linkage.
Let me take the latter point first. What the ALJ is saying, as I understand it, is to accept that the petitioner's argument would be to ignore this 10 milligram per liter standard of nitrogen, which is expressly set out.
But is that expressly set out for every discharge into any body of water in the Commonwealth of Massachusetts?
Yes, it is,
so
unless the DEP finds, Your Honor,
Yeah.
that there is a additional site-specific limit that should be imposed. And in this case, in an abundance of precaution, because the Edgartown Great Pond is so fragile, the DEP found just that there's an additional, more restrictive, site-specific limit that should be imposed. That limit is the 2,200 kilograms per year.
So, make sure, so there's a finding that the pond can tolerate up to so much nitrogen coming in per year.
Yes.
And then there is a finding that we project that the nitrogen coming into the pond in the future from all sources is going to be this, and with that, the amount that's coming from the plant is still going to keep it below our threshold.
That's correct, Your Honor.
Now, how it's so confusing because there are all these multiple scenarios. What is the basis on which the ALJ or the department can pick? Because some scenarios say, no, in fact, it will be over. It will be over. What's the basis for choosing one scenario over others?
Sound science, Your Honor, as detailed in the Wilcox report. And I would like to address these scenarios because I think they have been improperly characterized. The 9 scenarios that are presented in chart form in the petitioner's brief at page 6 do not fully reflect what the Wilcox report said about those scenarios. And I would commend the Wilcox report to you on this point. It starts at page 352 of the record. What Mr. Wilcox actually found, and this was a very sophisticated modeling effort. He describes his methodology in the report. He actually went around and counted homes. He looked at land use restrictions. He looked at what land was in conservation and could not be built, and he looked at what the growth could possibly be at a full build-out. Certainly a full build-out within Edgartown, within this watershed, could not happen as a practical matter within the 5-year term of this permit. So that's one answer, Your Honor, to the question why this permit doesn't expressly require that 310 homes be hooked up, because 310 homes currently have all the homes within the watershed aren't available to be hooked up until all that development should take place, if it does take place, which we hope it may not. But what Mr. Wilcox said is that the medium growth scenario is the most likely outcome, and he details his reasons based on his methodology. And then in choosing the appropriate loading limit, he looked at a range, low, medium, and high. He found that on the low limits, although the petitioner's briefs say that the current scenario would exceed the loading limit under a low nitrogen limit under all 3 scenarios. In fact, what Mr. Wilcox found, if you look at his report, is that if you follow his various recommendations for dealing with various other sources of nitrogen within the watershed, namely farms, septic systems, and other things, you could bring the watershed as a whole within even the low loading limit, except for it would be possible to do on a low growth scenario. It would be hard to do, but possible, very expensive at the most likely medium growth scenario. It would be completely impossible no matter what we did under the high growth scenario. I suggest that DEP shouldn't be forced into an interpretation of its regulations that says because we'll be over budget no matter what we do, we shouldn't do anything at all.
But because who will be over budget?
Because all of the sources of nitrogen within the watershed will together contribute to overloading the pond. We shouldn't do anything about the plant. But the scientific finding that
What's the maximum period of time for a license?
this is a 5-year
But can
permit.
it be issued for longer than 5 years?
I'm not aware of any. We had a 2-year permit initially in 1996 because this upgraded plant.
What was the date of the permit?
It was March of 96, and it ran for 2 years, and that was when the town.
No, the 5-year one.
The 5-year, March of 99.
It has been renewed.
It has been superseded by a new permit, which has been appealed again to DEP, and we are before an administrative.
Is that also
judge.
a 5-year permit?
That is also a 5-year permit.
Do the regulations say that you can issue a permit for no longer than 5 years?
I don't know the answer as I stand here, Your Honor. I can respond to that. But there is a scientific determination that the medium nitrogen limit is the most appropriate target. All these scenarios are not equally valid. Mr. Wilcox, through a study that was funded by EPA, this was not a paid consultant that the town signed up to write a report to suit its purposes. This was an independent study. And this man concluded with ample empirical study. There was empirical study of water quality, as well as a lot of land use planning work into this. This is the most appropriate target. This is what we should use for planning purposes. And based on that, DEP accepted that finding and relied on that recommendation. And that finding amply supports the conclusion that there's no regulatory violation whatsoever, because not only are we way, way below the 10 milligram per liter limit, we are meeting the site-specific standard that DEP determined applies here under the regulations.
Thank you, Ms. Goodhart.
Thank you.